The most important object in this story is not a photograph, a flight log, or a celebrity name. It is a 4-page letter dated June 30, 2026, sent by New Mexico Attorney General Raul Torres to Acting Attorney General Todd Blanche and Senior Justice Department official Diego Pestana. Its subject line warns of irreparable harm to a live criminal investigation. And inside that letter is a detailed accusation. New Mexico says the federal Justice Department has spent more than 130 days withholding unredacted Epstein records that state investigators need to identify survivors, witnesses, possible co-conspirators, and other people connected to Jeffrey Epstein's Zorro Ranch. That is what New Mexico investigators have now exposed. Not proof of a presidential order, and not proof that every redacted person committed a crime, but a documented conflict between federal promises of cooperation and a state investigator who says meaningful access still has not arrived. The dispute matters because New Mexico says it is conducting the only active criminal investigation focused on alleged crimes at Zorro Ranch, the roughly 10,000-acre property south of Santa Fe that Epstein owned for years. The state reopened its case in February after reviewing information released from previously sealed federal records. By March, investigators had returned to the property with the cooperation of its current owners. But according to Torres, the state cannot build a serious prosecution from pages where names, faces, dates, and identifying details remain blacked out. A redacted file may satisfy public disclosure rules. It does not necessarily satisfy a detective who needs to locate a witness, test an account, serve a subpoena, or establish who was present at a particular place and time. Torres's letter does not describe one unanswered email. It lays out a sequence. On February 13, New Mexico requested a specific document and related Zorro Ranch material. On March 13, the state sent another formal request, identifying 5 examples of heavily redacted records. On April 1, federal officials reportedly told New Mexico to use the formal TOHI process, the procedure agencies use when outsiders seek official records or testimony. New Mexico says it followed that instruction on May 3 and requested a response by May 11. It followed up on May 29. It sought an in-person meeting during Torres's June visit to Washington. According to the letter, no meeting occurred, no access was granted, and no substantive answer resolved the request. 6 steps, more than 4 months. Still no unredacted database. But fairness requires the other side of the record. The Justice Department disputes the suggestion that it simply ignored New Mexico. A department spokesperson told Reuters that the federal government responded in June, welcomes further investigation of Zorro Ranch, and stands ready to assist. The department also said it is prepared to investigate and potentially prosecute federal crimes uncovered by the state. That response is important. It means the established public record does not yet prove deliberate obstruction, a political command from Donald Trump, or an effort to protect any particular person. What it does prove is that the 2 law enforcement systems are describing the same exchange in sharply different terms. Washington says it responded. Santa Fe says it still does not have the records required to do the job. And this is where the phrase Trump Justice Department becomes relevant without becoming an excuse for speculation. Todd Blanche is the acting attorney general and President Trump's nominee for the permanent job. He previously served as Trump's personal defense lawyer. That history does not prove misconduct. But it guarantees that every decision involving politically sensitive Epstein material will be examined for independence, consistency, and appearance. When the head of the department has a close professional history with the president, assurances alone will never settle a dispute like this. The department must be able to show what it produced. When it produced it, what remains withheld, and the legal reason for every remaining restriction. The deeper problem began before the current administration. According to Torres's letter, New Mexico opened an investigation in 2019, gathered witness accounts, prepared investigative reports, and coordinated with federal prosecutors. The letter says the state halted its work at the express request of the U.S. Attorney's Office for the Southern District of New York, so federal authorities could consolidate material connected to Epstein and his alleged co-conspirators. On September 17, 2019, New Mexico says it sent its entire investigative file, including police reports and recorded witness interviews, to federal prosecutor Maureen Comey. The state requested notification if the federal investigation identified additional survivors of crimes in New Mexico. Torres says that notification never came. That history changes the meaning of the current standoff. New Mexico is not merely asking Washington to share somebody else's work. The state says it surrendered its own file in good faith, suspended its own investigation at federal request, and now cannot fully resume the case because the federal government controls both the transferred material and later investigative records. In institutional terms, that is the central accusation. Federal consolidation was supposed to prevent duplication and strengthen the case. New Mexico now argues that consolidation became a locked door. The historical lesson is familiar. Major investigations often fail not because no agency had information, but because information was divided, delayed, protected, or never moved across institutional boundaries. After September 11, the country learned the phrase failure to connect the dots. In the Epstein matter, the question is narrower but morally severe. Did one level of government ask another to stand down, receive its evidence, and then fail to return the information needed for state accountability? That question cannot be answered through partisan slogans. It can be answered only through production logs, correspondence, chain of custody records, and a clear accounting of who made each decision. The underlying crimes are not theoretical. Ghislaine Maxwell was convicted and sentenced to 20 years in federal prison for helping Epstein recruit and abuse underage girls. The Justice Department's own sentencing announcement said victims were groomed or abused at residences in New York, Florida, and New Mexico. That does not establish that every allegation connected to Zorro Ranch is true. It does establish that New Mexico was part of the proven geography of the Epstein-Maxwell scheme. The ranch was not simply an exotic backdrop in a scandal about famous people. It was one of the locations tied to a criminal operation that produced a federal conviction. New Mexico lawmakers have also created a separate House investigative committee. House Resolution 1 was introduced by Andrea Romero, Mariana Anaya, Andrea Reeb, and William Hall. It created a 4-member bipartisan committee with authority to hold hearings, compel witnesses, administer oaths, and issue subpoenas. The resolution requires an interim report by July 31 and a final report by December 31. State budget documents allocated $2 million to the inquiry. That legislative investigation is not the same as Torres's criminal case. Lawmakers can expose institutional failure and recommend new laws. Prosecutors must meet rules of evidence, jurisdiction, statutes of limitation, and proof beyond a reasonable doubt. The two tracks may support one another, but they cannot substitute for one another. Here is the dimension most coverage misses. Redactions protect legitimate interests, especially survivor privacy. No responsible investigator wants names of victims dumped onto the internet. But New Mexico is not asking the Justice Department to post unredacted records publicly. Torres says The state is prepared to accept security rules, confidentiality conditions, database restrictions, and protective agreements. That distinction is critical. Public disclosure and controlled law enforcement access are not the same thing. A department can protect victims from public exposure while still giving vetted prosecutors the identities and records needed to contact them safely. The clock now matters. Torres's letter warns that witnesses move, memories fade, documents become harder to authenticate, and physical evidence deteriorates. The ranch was sold in 2023, and the alleged conduct reaches back many years. Delay can create statute of limitations disputes and due process arguments, even when investigators eventually locate strong evidence. A prosecution is not built from outrage. It is built from admissible records, corroborated testimony, authenticated documents, and lawful warrants. Every lost month can narrow those options. That is why the June 30 letter sets July 31 as the deadline for access or production. If the records do not arrive, New Mexico says it will treat the request as denied. This is also why the title of this story must be understood precisely. New Mexico has exposed a paper trail. It has exposed the dates of its requests. It has exposed the earlier transfer of its 2019 file. It has exposed the difference between verbal assurances and the state's claim that usable records remain unavailable. But New Mexico has not yet publicly proven why the delay occurred. Administrative failure is possible. Legal caution is possible. Interagency dysfunction is possible. Political interference is also a question investigators and lawmakers are entitled to examine, but it remains a question unless evidence establishes it. Serious reporting does not weaken a story by drawing that line. It makes the story harder to dismiss. For President Trump, the political risk is therefore institutional as much as personal. Any appearance in an Epstein-related record does not by itself establish wrongdoing, and allegations in raw investigative files may be unverified or false. The greater immediate problem is whether his administration can demonstrate that politically sensitive evidence is handled by rules that apply equally to allies, adversaries, famous names, and unknown names. A Justice Department earns trust through transparent procedures, not through demands that the public stop asking. If the department has a lawful basis for withholding specific material from New Mexico, it should state that basis. If it has already provided the needed access, it should document the production. If it has not, it should explain the delay and fix it. For ordinary Americans, this is not merely another Washington fight. It concerns whether state and federal authorities can cooperate when wealth, influence, and institutional reputation are involved. It concerns whether survivors are treated as witnesses to be found or names to remain hidden behind permanent black bars. It concerns whether a government that asks citizens to trust sealed processes can later provide an audit trail showing that the process served justice rather than convenience. The rule of law is tested most severely when the people around a case are powerful enough to make delay feel normal. The next decisive moment is not a television appearance. It is July 31. By that date, New Mexico expects access to relevant unredacted records, and the state legislative committee is also due to deliver its interim report. Those two events could reveal whether the conflict is being resolved or becoming a formal confrontation. They may show what the Justice Department actually produced, which requests remain outstanding, and whether subpoenas or litigation follow.